Hello, Carla Hartley here. Today I'm continuing our discussion of the factors the court must consider when a parent applies to move away with a minor child or children. Today we're discussing factor 6, which is the child's or the children's relationships. This would seem to be a no-brainer, but like everything in the law, we can come up with stuff to make it complicated or to at least make it interesting. So today I'm going to break down the children's relationships which must be considered into 3 different categories. The first category is the child or the children's relationship with the parents. Obviously, this is something that has to be considered. Generally, what we see in a move away is going to be one of 2 scenarios. Either one parent is saying the kid hates the other parent, doesn't want to be around him, in which case the other parent is saying, no, my kids love me, it's fabulous. You're looking at a custodial evaluation, a psych evaluation, all sorts of stuff before the court can get this done. Because when you have that big of a separation, unless the kid or children, when they go talk to the mediator or the child custody recommending counselor, unless they say exactly what one of the parents or the other one is saying, this is just a complicated situation. I want to caution you that if you're one of the parents saying the kid hates the other parent, then you're going to want to really listen to factor 7, because that is where that can really turn around and bite you pretty hard on a video that's going to be published, so I'm not going to say where it's going to bite you. All right, so with the parents, most times what we have is a kid or children who love both their parents, and one of them is moving. And a lot of our judges will say this is one of the saddest things they have to deal with, because it is going to disrupt the child's life, the children's lives, their relationships with one parent, their access to the other parent, stuff like that. This has to be looked at, and the court's going to make certain findings. The custodial evaluator, if one is involved, is going to make certain findings that the court must consider. So since that one's so obvious, I'm not going to focus on that. That's more a question of fact and not so much a question of law. The next category of relationship the court must consider is the relationship, the child or the children's relationships with siblings and half-siblings. There is a policy, when you're dealing with siblings, there is a policy with the court not to separate siblings unless it is really in the best interest of the children to do so. There's some stringent law on this, and the court has got to make such rigid findings that you're really not going to get into a separation of siblings. For the most part, there are exceptions, but you're going to probably be looking at involving minors counsel at some point, or and certainly I would expect some sort of more in-depth investigation into what's going on in the home than you're simply going to get from showing up at the court and say, hey, this is what's happening. So siblings, there's a body of case law on this. When you have a disabled sibling, even then, often that is not enough to separate siblings. So be cautious. If you're wanting to move away, or you're the parent trying to block a move away, this is a big factor. If one child really wants to stay with one parent and the other child really wants to go, we've got a problem. And very often the court will perceive that problem as being created by the parents. There has to be a history, a significant history that you can offer up for evidence if you're trying to create or benefit from that scenario. Half-siblings. Half-siblings are not quite so stringently regarded, but they are a consideration. If the child is really tightly bonded to half-siblings in one home and the other home is just one parent with nobody else, that's something the court's going to look at. If there are half-siblings in both homes, the court's going to look at that. How are we going to keep these relationships good? Because one thing the courts are very aware of is that the more family a child has, very often the healthier that child's going to be. There's I think, this is my opinion, there's competition within a family arrangement, all right? If you have multiple children and extended family members. You've got one grandma who's sweet and the other grandma who's crotchety. This teaches children to deal with different personalities in a very safe environment. So keep that in mind. The court is going to be looking at an arrangement that's going to keep siblings together, keep half siblings in some type of relationship with the children who are moving away, unless there is something toxic in those relationships. And it's got to be toxic meeting a legal standard, not just one party thinks it's toxic. I'm not going into the legal standard for that. So the next and really not particularly considered set of relationships that we do see parents using, the peer groups. I have had more than one judge say, look, this kid's not going to keep these friends forever. Usually at this point we're dealing with, well, we've dealt with children of every age. We've dealt with the 17-year-old who doesn't want to leave her high school or his high school. We've dealt with, the 6-year-old who doesn't want to leave their best friend next door. Peers don't really, the peer group doesn't really have a standing to be considered or isn't qualified to be considered under the law as the law currently stands. I am unaware of any cases coming down that would alter this, because the court, keep in mind, the court has to draw the line somewhere, and the court is expecting parents to be the parents and to be the decision makers. So with regard to this, your peers don't tell you where you can go if you're a child, and the parents really can't use the children's peers in this, because again, that's weaponizing children, and we don't want to do that. That is factor number 6, the child's relationships. I have, and I must say this, ridiculously oversimplified this to try to make this something that will tweak your interest, have you discuss it with counsel, but don't hang your hat on it unless you've discussed it with counsel and you have all of the little evidentiary facts necessary for the court to make the necessary findings in this regard. I hope this has been helpful. I hope this whole series is proving helpful to you, and I hope you have a good weekend. Bye-bye.